going to get started. Thanks you all for coming. So we have a very distinguished speaker tonight. I'm going to go ahead and let him introduce himself because I think he can do a better job than I could. And without any further ado, I'm going to go ahead and let him get started.
Thank you. It is a privilege to be here, and I think it's great that so many people are interested in the law and in this issue particularly. It's important to me. My name is Joe Martineau. I'm with a firm downtown called Lewis Rice. I've practiced law for about 35 years now. A good part of my practice is representing media entities, and in that role I've become very familiar with First Amendment issues. There are First Amendment issues that I never get involved with, but I think in general that I have a certain degree of expertise in that. And I'm going to be talking tonight about the First Amendment, and I'm going to try to keep it. I'm going to try to keep it topical. I read the newspaper on a regular basis. I hope you do. I watch the news. I keep in touch with the internet and what's being reported, and sometimes it's real, sometimes it's fake. It's important to keep in touch with things that are going on. And I'm not real adept at. I thought I'd start this way. What they've asked me to focus on is, well, how does the First Amendment interact with today's internet, social media, the quickness that word spreads, that news spreads, and so I kind of jotted down some thoughts that I had. First, real news spreads faster, often faster than traditional media can possibly relay it. I think it's important to keep that in mind. Sometimes what you see in the newspaper, you've already heard about through the internet. Those of you who keep in touch with things on the internet. And sometimes the internet can report things incorrectly. That gets us to the second bullet. Fake news, lies, and even hateful speech are spread quickly and easily. Because social media permits fast and broad communication, organized protests are more readily arranged. I'm sure you've heard about some of the spot protests that just develop very quickly, and that creates that is a First Amendment issue in and of itself. It's easier to steal or mistakenly use proprietary or copyrighted materials, and we're going to talk about all these things tonight. But you can see things on the internet, you can take things from the internet, you can copy things from the internet. And there are hazards and risks in doing that we'll talk about. Information can be leaked and or hacked, and it can be released anonymously. Politicians and government officials can control their message by denying information to traditional media and using their own social media. We've seen examples of that with both the current administration in the state and the current administration in the federal system. Harassment and stalking are possible just by sitting at your computer. People can be harassed, bullied by somebody who's sitting miles and miles and miles and miles away, just sitting there at a desktop computer or a laptop computer. News from decades ago is readily available, but sometimes it may omit subsequent events. In other words, bad news survives, but good news may not be available. If you've been arrested, it may be in a newspaper, it may be on the internet, but the fact that the arrest was later shown to be improvident, inappropriate, and that no charges are ever brought, that may not be available on the internet. And then finally, in some respects, privacy, or in many respects, as a matter of fact, privacy has become a thing of the past. The place to start, and the place I want to start tonight, is with the text of the First Amendment. It's just, the part we're going to be focusing on tonight is just 33 words. We're talking about free speech. Now, the First Amendment includes not just the right of free speech, but also freedom of religion and the prohibition on the government establishing a religion. We're not going to be talking about religious freedom tonight. We're going to be talking about the speech component. And it's important to start with the text of the First Amendment. The text. Congress shall make no law abridging the freedom of speech or of the press or the right of the people to peaceably assemble and petition the government for a redress of grievances. Let's talk about what that means, or at least what the Supreme Court has said it means, because the Supreme Court is the body, the ultimate body, that discerns or decides what the First Amendment means and what all the provisions of the Constitution mean. Congress. The prohibition against restrictions on free speech is not limited to legislation coming from Congress. Even though the First Amendment was adopted, and the words of the First Amendment are a prohibition on Congress, as it's been interpreted by the Supreme Court. And I think consistent with what the framers of the Constitution intended, the First Amendment applies to any arm of government, not just Congress or even the federal government, but also the states and local government. So the First Amendment is not limited to legislation coming from Congress, but applies to any arm of government. Importantly, it's not applicable to private entities. The First Amendment only applies to the government, not to private entities. Congress shall make no law. Well, that sounds pretty absolute, but as it's been interpreted by the Supreme Court, and again, consistent probably with the intentions of the framers of the Constitution, it's not an absolute prohibition on any restriction on speech, but a strong presumption in favor of free speech rights. And in that regard, what the Supreme Court has said is that content-based restrictions, and when I say content-based restrictions, what I'm talking about is a restriction that's based upon the message, the substance of what's being communicated. There's a very strong presumption, and sometimes the courts, and frequently the courts refer to it as strict construction, against the validity of any law or restriction of speech based upon the content of the message conveyed. And the Supreme Court, in a recent case, Ashcroft versus American Civil Liberties Union, repeated that. As a general matter, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. On the other side of the equation, context-based restrictions, not content-based, but context, restrictions based upon when, where, how speech is expressed, are much more liberally allowed. Reasonable protections, or restrictions rather, on time, place, and manner, which are applied regardless of the content, regardless of the message, are generally allowed, providing there are reasonable alternatives for the expression available. So you can have a restriction on sound trucks in the middle of a residential neighborhood. You could not have a restriction on somebody going through a residential neighborhood because they are supporting Donald Trump and because they don't support Hillary Clinton. That would be a content-based restriction. The other thing to keep in mind is that sometimes context-based restrictions can be a pretext, can be an excuse for what really is a content-based restriction. So always keep that in the back of your mind. Freedom of speech. Congress shall make no law abridging the freedom of speech. Speech, as it's been interpreted by the Supreme Court, is not limited to the spoken word, the written word, but can also include something known as symbolic speech. I'm sure you've heard, and you probably have opinions about it, burning flags, stomping on the flag, putting excrement on the Virgin Mary, things like that. That is symbolic speech. And the First Amendment protects symbolic speech as well as speech that's spoken, speech that's written. Or of the press. This is kind of interesting because you would think, well, the First Amendment talks about freedom of speech and freedom of the press. Well, they must be different things, right? The Supreme Court really hasn't said that. In fact, the Supreme Court has pretty much said that's not the case, that the press has no greater rights than you or I. that they have no greater rights than any other citizen. Now, there is one area where they may be an exception to that, and we'll talk about that later, and that area is in the situation where a reporter has a confidential source that reveals valuable information. The courts, with some reluctance and with some ambiguity, as a matter of fact, have protected sources who come to the press with confidential information. But that's not a privilege you or I would have. Now, I would have it as an attorney. Someone comes to me and there's an attorney-client privilege, but if your best friend comes to you and says, well, I just murdered my wife and buried her, you know, or buried her behind a tree in the park, and they want to subpoena you, the government wants to subpoena you to find out what you know, you don't have a privilege. You don't have a privilege, but a reporter might. Maybe not in that context, but that's what I'm talking about. You're all going to say, well, I don't get to go to the Oval Office, or I don't go to a press conference in the White House. I don't even get to go to Steve Stenger's press conferences. There's not enough room. And that is a question of regulation by context, where you can only let so many people in. Now, it would be improper to say, and this happened not too long ago, when CNN and the Washington Post and can't remember another news media entity were not allowed in a Trump press conference. Now, if that was by design, and if the reason for that was we don't like what you're reporting about us, that would be a content-based restriction, and that would have been improper. Peaceably assemble. We'll talk about that, and that's been, you know, a big issue in this community and throughout the country, as a matter of fact, the right to protest. Context-based restrictions on peaceable assemblies and protests are generally permissible as long as they are not, again, as long as they are not a pretext for content-based restriction. You couldn't let the Girl Scouts marched through the park, Forest Park, but then prohibit the Nazis from marching through Forest Park because you don't like what Nazis say. Now, I don't like what Nazis say, and I'm sure no one here likes what Nazis say, but that would be a content-based restriction. Let's see if I can do this right now. So what does the First Amendment protect? Ultimately, it protects the right to express viewpoints free of government restriction. It protects the right to petition the government. To a limited extent, it protects or provides a right to obtain information from the government. As we talked about a few minutes ago, it protects the right to symbolic expression, but not symbolic acts, which itself is criminal. So I said burning a flag earlier. You can't ban burning a flag because of the message being conveyed, but it would be criminal and it would be a crime for me to light a flag on fire in this auditorium. That would be a perfectly proper restriction. Non-discriminatory, and I'm not talking about discriminatory in the sense of race or sex or something like that. I'm talking about non-discriminatory context-based regulation is generally allowed. In other words, reasonable time, manner, and place restrictions on speech, when, how, where. Content viewpoint-based discrimination of speech is generally invalid. Discrimination based on the identity of the speaker or the content of the speech is generally invalid. Prior restraints, we'll talk about prior restraints in just a second, are generally invalid. There are exceptions for vital national security, copyright, invasion of privacy by appropriation, and pornography. And what I mean when I say prior restraints, it's a prohibition on speech before it's expressed. Defamatory speech, and we'll talk about that a little bit tonight, can be regulated. Speech that's defamatory of a particular person can be regulated through court-ordered civil money damages after publication, and, though not entirely clear, perhaps criminally, providing it is proven false and at least negligently, or in cases involving public persons, public figures, public officials, and we'll talk about that in a minute, recklessly made. Invasion of privacy can be regulated without violating the First Amendment. Speech which discloses previously unknown public and private affairs of a person may be sanctioned through court-ordered civil money damages, and similarly, acts which unreasonably intrude upon a person's personal privacy, a person's personal space, can also be made unlawful without violating the First Amendment. Intellectual property rights, rights of publicity. We're going to talk about that at the end of the evening tonight. The First Amendment does not prevent adoption of laws protecting intellectual property. And by intellectual property, I'm talking about copyright. I'm talking about the right of a public persona, an actor or an actress, to prohibit someone from using their name, likeness, or visible features for commercial purposes. That's all in the context of intellectual property. Under copyright laws, tangible works of expression, things that are fixed in some sort of tangible medium or tangible way, can be protected. However, the First Amendment would generally invalidate any use of intellectual property to preclude use of such matters in news, biography, criticism, parody, entertainment, even fictional entertainment, which is not defamatory. Again, we're going to talk about that. We're going to talk about all of these things tonight. Commercial speech and advertising. The Supreme Court has said that the government has much greater leeway in regulating commercial speech than in other forms of speech. That if you're talking about, and when I talk about commercial speech, I'm talking about speech. Selling a newspaper is not considered commercial speech. Selling a magazine, even charging admission to a movie is not considered commercial speech. What I'm talking about when I'm talking about commercial speech, or what the court is talking about when it's talking about commercial speech, is speech that has as its primary purpose encouraging some sort of economic transaction, the sale of a good, the sale of a service, an ad. And ads are subject to greater regulation, or so the Supreme Court has told us. The broadcast media, although it's not quite the same as it was 30, 40 years ago when the broadcast media was 4 or 5 television stations and maybe 20 or 30 radio stations, because now you've got cable, you've got the internet, you've got everything else. But the traditional broadcast media, those entities that own a broadcast license that's granted to them by the FCC, the Supreme Court in a case called Red Lion versus FCC many years ago said that because they are given a monopoly on certain airwaves, and because of that they have an obligation to act in the public good, that they're subject to greater restrictions without violating the First Amendment. It's why you've probably heard the 7 dirty words you can't say on television or on radio. I think that comes out of, who was a comedian, George Carlin. Comes from that. That's why the 7 dirty words you can't say on radio or television, at least before 10 o'clock at night. I think the FCC allows liberty after 10. What about the internet? That was kind of undecided for many years. Is the internet the same as the broadcast media, or is the internet like newspapers? And the Supreme Court in Reno versus ACLU, and most of Reno versus ACLU involved child pornography and access of children, or access children might have to obscenity on the internet. But in that case, as part of that case, the court said the internet receives the same protection as any other form of speech, not the limited protection that would be applied to the broadcast media. Moving on, fighting words, clear and present danger. Speech is action. Speech that does not merely express a viewpoint, but action is not protected. Example, threats of physical violence, fraud, race or sex discrimination, or harassment. The Supreme Court has said, no, you can't claim First Amendment right to harass somebody or discriminate against someone sexually. Another example are fighting words. Speech which is intended to incite imminent lawless action and is likely to have that effect. It can't just be someone getting up and abstractly saying, overthrow the country, kill the president. It's got to be something that's more than just being abstract. It's got to be imminent and likely to result in that action before the government can regulate it. And finally, the Supreme Court has very clearly said that obscenity, pornography, is not protected in any fashion by the First Amendment. When you're considering speech and a regulation of speech, I think there's a few things you should always, or you should look at it from a certain perspective. First, who is doing the regulation? Remember, if it's not a governmental entity, if it's Wash U or St. Louis U, there's no First Amendment issue. Now, there may be other issues because there are federal statutes that say if you participate in the student loan program, you have to afford students certain rights, you have to afford academicians certain rights of free speech. But it's not a First Amendment issue. It's not a First Amendment issue. My son, who's now in college, well in college, hopefully he graduates this semester, he's been a little secretive about whether he has enough credits or not, but we'll find out. But he used to tell me when he was growing up, well, you represent newspapers, you represent the television stations, you believe in the First Amendment. Well, why can't I say that? Why can't I do that? I said, the First Amendment doesn't apply in this household, Robbie. It does not apply in this household. I'm the boss, I'm the king, you have to do what I tell you to do. That's not the case any longer, by the way, but so who is doing the regulation? Then who is being regulated? Some media receive less protection. Example, the broadcast media. What is being regulated? Again, some types of speech receive less protection. Commercial speech, advertisements receive less protection. So look at that. Why is the regulation promulgated? How is the regulation being accomplished? And is the regulation based on content or context? And that last thing is probably the most important. That's always the first thing you should look at. Are we talking about a content-based restriction here? Are we prohibiting this protest because we don't like the Black Lives Matter movement? Or are we just prohibiting it because they can't be walking down the middle of Main Street during rush hour? Or is it a pretext because we don't like the Black Lives Matter movement? So keep all that in the back of your mind when you consider these issues. I told you we talk about prior restraints. Again, prior restraints are restrictions on speech before publication. And the Supreme Court has very clearly said that prior restraints are constitutionally infirm under the First Amendment. And normally when you see a prior restraint, it comes in one of two forms, either an injunction, that's where a court enters an order prohibiting someone from doing something. It could be prohibiting someone from walking across your backyard on a regular basis. Well, that wouldn't be a First Amendment issue, but that would still be an injunction. But you can have courts sometimes enjoin speech. We've had instances over the years, in my 35 years, not often, but we've had instances where a judge has entered an injunction against publication of a certain news article because the subject of that article has found out about it, hired lawyers, gone into court, and asked for an injunction against the publication. Those injunctions have always been very short-lived because they've been quickly reversed. And in one instance, it resulted in the newspaper leaving a blank page there saying, we can't tell you what we're going to tell you because a judge has enjoined us. And then the very next week, a big, bold front page headline of that story when the injunction had been lifted. So that's what an injunction is. And then you can also have censorship when a government entity requires submission and approval of material proposed prior to its publication. That may work with the military. And who was the woman who worked for the CIA who was outed by Valerie Flame. Her book, she wrote a book that had to be submitted to the CIA. That was not a First Amendment violation because when she took that job with the CIA, she signed a contract essentially giving away her First Amendment rights. and the CIA censored portions of that book. So I thought these were interesting little drawings. The worst part of censorship is, well, I don't know, because the government says I can't tell you. And then there was years ago, I don't know if any of you are Saturday Night Live fans, when in the old, pardon? The old crew, well, their ratings have gone through the roof now, right? But the old crew that I remember growing up, 77, 78, 79, the Dan Aykroyd, Gilda Radner crew, they had one thing where they had the evening news, and they came out and they said, oh, we finally know, we've got through the FOIA, we finally know who shot Kennedy, or who really shot Kennedy, and they hold up this piece of paper with nothing but redactions on it. That's censorship. In a case going back to 1931, the U.S. Supreme Court reversed an injunction against a newspaper publisher which had published critical, false, and defamatory statements about elected officials in the city of Minneapolis, I believe it was. It might have been St. Paul. And the Supreme Court said, no, you can't have a prior restraint. Prior restraints are violative of the First Amendment except in very narrow circumstances, including the disclosure of national security matters, especially publications, and this is right out of the Supreme Court opinion, especially publications during wartime disclosing troop movements. Well, that's obvious. You can't be telling your enemy when you're going to invade. Military interference with military recruitment efforts. I think they said that because there was a line of cases during World War I where persons who interfered with the draft were prosecuted. I don't know where the court would come down on that today. Obscenity. I've told you obscenity doesn't receive any First Amendment protection. So because of that, obviously, you can have a prior restraint. You can prohibit it. If you get to, if you can find the obscene materials before they're circulated, you can either enjoin them or seize them. Utterances which have the effect of force. In other words, words which directly and imminently cause incitement to acts of violence and the overthrow by force of orderly government. It can be very difficult at times on that last thing, what sometimes is referred to as clear and present danger, fighting words. It can be very difficult. Where do you cross the line between protected First Amendment speech? Where is it abstract enough, and where has it become so imminent and so likely that it's going to cause somebody to do something they shouldn't do, something illegal, that it becomes a violation of the First Amendment? We're not going to talk about that tonight, but I mean, it is a difficult issue. Moving on. One of the things that we're all hearing about these days is fake news. And fake news, you would think that it just came about in the last, 4 or 5 years. That's not true. I did some research. Fake news is not especially new, especially in politics. When Thomas Jefferson and John Adams were vying to succeed George Washington as president, reports came out that Adams wanted to be king of the U.S. by trying to marry off one of his sons to a daughter of the English King George III, and George Washington blocked that and saved the country. That was published presumably by, or pushed around, or the rumor was spread presumably by Jeffersonian advocates, people who were supporting Jefferson and weren't supporting Adams. That clearly is fake news. So fake news is not news, or new rather. What's new about it is we hear about it so much, and the fact that it's so easy now, and it's so much more difficult, I think. In fact, you were asking me about that before. Well, how do you decide, what is reliable and what isn't? And it's difficult. There's all these websites out there that push stuff, and some of them are very similar to established media entities. And then there's a lot of distrust of the media in general. But fake news is not new. And I put some tips in here. You should consider the source, check the author, check the date, Check your biases, because they all play to our biases. You may be conservative, you may be liberal, but always, regardless of which side of the coin you're on, be careful and think about what you're seeing and look for other sources, look for other places. I represent the media. I'm a huge fan of the media. I don't always agree with the media. I don't always think it's responsible in the way it reports things. But what I will say about the traditional media, Channel 4, the Post-Dispatch, the St. Louis Business Journal, is that what they put out is vetted. And what do I mean by that? There are editors that are questioning the reporters, and there are editors that are questioning the editors. So it's not just one person, a blogger per se, putting something out there. There is that process that it goes through. And most members of the media are professionally trained. They're not necessarily professionals, because one thing you don't have to have in this country, and that's because of the First Amendment, there's no such thing as a license to be a reporter. I mean, that would be censorship. That would be censorship. If you required someone to have a license to be a reporter, to report news, to basically speak, that would be a restriction on speech, and that would be a violation of the First Amendment. Can't do it. Yeah.
No license is required to be reported.
No license. I don't know how I can say it any clearer. No license is required to be reported. Now, most established media will look for somebody that's got a degree in journalism, has studied journalism, but there's no government entity like there is for lawyers, like Jen and I, barbers, doctors, and I've heard about hair braiders. There's big controversy about hair braiders needing a license, but journalists don't need a license, and I think that's a good thing. I mean, if they needed a license, the whole purpose of the First Amendment is to protect against the government deciding what's right and what's wrong, and that's why you don't have a license or anything like that, something that's given out by the government to be a journalist. You may think you should, but who's going to be issuing those licenses? And I generally trust the government, and I think we all should generally trust the government, but it's not always right, and it's not always the right way to go. And look what's happening in Russia with what's his name? I couldn't say it. Being arrested in the last few days. Read beyond. Look for supporting sources. Is it a joke? It's so easy to put fake news out there without really expecting that people are going to rely on it. Think about what you're seeing. Is it really intended to be real? And then I put ask the experts. Well, it depends on the subject matter, obviously, who the expert is. But, be inquisitive. You should question what you read. You should question what you see in the media. And that's the only real way, as we're going to see in a second, to cure fake news. Is there anything the government can do about fake news? And I put here, really, not much. Not much. There is a case that was decided just a few years ago called United States versus Alvarez. This man, he's pictured there, did an absolutely deplorable thing. He held himself as a recipient of the Congressional Medal of Honor. The Supreme Court, in deciding the case, said lying was his habit. Xavier Alvarez lied when he said that he played hockey for the Detroit Red Wings and that he once married a starlet from Mexico. But when he lied in announcing he had the Congressional Medal of Honor, he ventured into new ground. For that, he violates the federal criminal statute, the Stolen Valor Act of 2005. The Stolen Valor Act was an act enacted by Congress that made it illegal, made it criminal to falsely hold yourself out as receiving the Congressional Medal of Honor, and maybe some other military honors. I'm not sure about that. But the Supreme Court said, no, that statute's unconstitutional. It's a violation of the First Amendment. And what the Supreme Court said is there's only certain, that would be a content-based restriction, right? A content-based. And there's only certain content-based restrictions that we as a Supreme Court, as a court, have allowed, and those have been historically allowed, and we're not going to expand it. We're not going to allow lying, even when it's lying about the Congressional Medal of Honor, to be made criminal. And so that's why I say, well, there's probably not much we can do to stop fake news. The government can't make it criminal. The government can't make it criminal. The types of speech, again, we talked about it earlier, but the types of speech types of content-based restrictions, rather, that have been allowed, or where the court has allowed restrictions, would be like fighting words, advocacy intended to incite imminent lawless action, obscenity, child pornography, defamation, speech integral to criminal conduct, fraud, true threats, and speech presenting some grave and imminent threat the government has a power to prevent. That's, again, disclosure of national security secrets or something like that. And the Supreme Court said, it's the second bullet down here, one of the costs of the First Amendment is that it protects speech we detest as well as the speech we embrace. Though few might find respondents, and respondents was Mr. Alvarez, statements anything but contemptible, his right to make those statements is protected by the Constitution's guarantee of freedom of speech and expression. That's just how far the court has gone in protecting free speech, so that lying about having the Congressional Medal of Honor cannot be made criminal. Cannot be made criminal. This is a great one. Was Donald Trump right about libel law? You may remember. First, what is libel law? When I'm talking about libel law, I'm talking about defamation, when you make false statements about people. And what you may remember during the campaign, it was in Fort Worth, Texas, on February 2nd of last year. Donald Trump, who was upset about things that were being reported about him, said, one of the things I'm going to do if I win, I'm going to open up our libel laws, so when they write purposely negative and horrible and false articles, we can sue them and win lots of money. We're going to open up those libel laws. That's what he said. Was he right? No, he's wrong. Use his words, wrong. Mostly wrong. Mostly wrong. And why was he mostly wrong? Well, first, he was wrong because nobody has ever said, no court has ever said that purposely false statements of fact that are defamatory of a person. I'm not talking about lying about the Congressional Medal of Honor. I'm talking about statements that defame a person, harms a person's reputation. Purposely false statements of fact are not protected from libel, never have been. Never have been, and we'll talk about that in a minute. Why do I say he was mostly wrong? Because purposely negative and horrible opinions, I think Trump's a terrible president. I think Hillary would have been a disaster. Those kinds of statements are generally protected from libel, even if they're negative and even if they're horrible. Those are protected from libel. So he was right in that sense. When people say, you're a terrible person, Mr. Trump, that's protected. But if they were to say falsely about him that he molested children, that would be defamatory and that would be actionable. That would be actionable as defamation. Let's talk about defamation for a minute, because that's a very important subject when you're talking about the First Amendment. In a libel case, a person suing, the plaintiff, must prove certain things. And to understand a libel case, you should know what they have to prove. First, a publication or republication to a third person. In other words, I don't libel you if I say you're a child molester and you're the only person that handles it, or hears it rather. That's not a libel. Some third person has to hear it. It may offend you, it may hurt your feelings, it may cause you to punch me in the nose, but that's not libel because it's not a publication under the law. And when I say republication, there's a awful belief that people have that just because someone else said it, I can repeat it. You know, Mrs. Brown says that X is a child molester. Well, if Mrs. Brown said it, Mrs. Brown may be liable for libel or slander. But if I repeat it, I'm probably liable as well. a spreader of false statements is just as liable as and in fact, they could have greater liability, because if we're talking about you going to the Post-Dispatch with that information, saying that Mr. X is a child molester, and the Post-Dispatch reports it, they've just magnified the damages and magnified the harm how many times? By their, 80,000, 90,000 readers. So a republication, now there's certain privileges that apply, but we're not going to get into those tonight. But for the most part, if somebody publishes or republishes a false statement, that's what it takes for a libel, communication to a third person. It has to be a defamatory statement, a publication or republication of a defamatory statement. Something isn't defamatory just because it hurts your feelings or it's embarrassing or something like that. It has to be something more serious than that. An accusation of a crime, a lack of integrity in your trade or business, a accusation of unethical behavior in your trade or business, an accusation of immoral behavior. And the courts have said it has to harm a person's reputation in the eyes of right-thinking people. Believe it or not, over the course of the years, I've had 4 different cases where someone complained that they had been falsely accused of informing law enforcement about their cohort's criminal activities, that they were a rat. And they claim, well, that harmed my reputation, that hurt me, I'm in jail, I'm in danger because now people think I'm an informer. No, the law says it has to be among right-thinking people. There's nothing wrong with informing on someone's criminal behavior. So a publication or republication of a defamatory statement which is provably and materially false. Provably and materially false. And what do I mean when I say materially false? It has to be false in the sense that it makes a difference. We're going to talk in a minute about a case called New York Times against Sullivan, the most significant First Amendment case in the field of defamation that there is. It goes back to 1964. In that case, Commissioner Sullivan, who was in charge of the police department in Selma, Alabama, sued the New York Times, and he won $500,000 in Alabama over an ad that was published in the New York Times. It wasn't even something the New York Times put in there. It was an ad that was paid for by civil rights advocates, the Reverend Ralph Abernathy and others, talking about abuses of civil rights marchers in the First Amendment, or in the South, rather. And one of the falsehoods in that case was that the students that were harassed, the civil rights marchers that were harassed, were singing the Star-Spangled Banner. That was false. They were singing My Country 'Tis of Thee. That was one of the falsehoods. Well, that doesn't make a difference. That's not material to whether or not Mr. Sullivan's or Commissioner Sullivan's reputation was harmed. So that's what I mean when I say it has to be material. We've had cases where it was reported that someone who's in prison was in prison for murder and rape. And they sue claiming, well, we didn't rape anybody, we just murdered somebody. Is that material? I actually had a case once where, you're not going to believe this, where a gentleman who beat his wife, it was inaccurately reported in my client's newspaper because when the arrest report came out, everything was off by one line. In other words, the name, the charge, the name, the charge. It was accidentally reported by the newspaper that he was arrested for having marijuana and paraphernalia. He claimed that that was false. It was. He claimed that it was defamatory of him. But he had been charged and convicted of beating his wife, of domestic abuse. And when I took his deposition, I asked him, well, what's the difference? I mean, it seems to me that beating your wife is a lot worse than smoking a joint. Oh, no. This is I can't get a job now. I can't get a job now. The judge kind of laughed his case out of court. It was ridiculous. But that's what I mean when I say materially false, which is about the plaintiff. It has, yeah. I was going to talk about Pizzagate. What?
Defamation? Could she have sued the person who broke his story?
Pizzagate, the thing that led to that guy coming into the pizza parlor and threatening people, and it was fake news. Probably, if she could have figured out who it was, and if she wanted to do it. I mean, the same question was asked about a week ago. Could Donald Trump be sued by President Obama, over the wiretapping thing, which, I don't know what the truth is there. I mean, we hear so many different things, but why would he? Why would he? I mean, so you can have a defamation and nothing may ever come of it because nobody ever sues. Plus, they're a public official, and as we will see in a minute, they have to prove actual malice, that they knew it was false or seriously doubted the truth. I don't know if Obama did. I don't know if whoever reported the Pizzagate they did. He may have just been simple-minded enough to actually believe. Now, I'm not talking about the president. I'm talking about Pizzagate. Simple-minded enough to believe that she did. I mean, there were a lot of people who believed a lot of things about Hillary, and some of them, I mean, I've heard things from people I know and friends, and some of them seem pretty far-fetched. And these are reasonable people. These are reasonable people. I don't know if you saw it today. You know who Roger Daltrey is? Lead singer of The Who. What did he say today? He said that she couldn't have beaten a dead dog. He said the reason Trump's the president is because Hillary couldn't beat a dead dog. Now, that would be a statement of opinion, by the way. Anyway, which is about the plaintiff. I hope I answered your question. Which is about the plaintiff. It has to be about the plaintiff. It can't be about your father. It can't be about your mother. And you have to be alive, too. There's no such thing as libel of the dead, at least not legally. If the plaintiff is a public official or public figure, the plaintiff has to prove. Right, that the defendant made the statement, the person being sued, the publisher of the statement, made the statement with either actual knowledge that it was false, knowing it was false, in other words, a knowing lie, a purposeful lie, as Donald Trump said, or with serious doubts about the truth. Really questioning it and going ahead recklessly and reporting it anyway. That's what a public figure, a public official has to prove, and that's a result of New York Times against Sullivan, which we're going to talk about in a minute. It's very difficult. It's very difficult, but there have been cases where public officials have prevailed. Relying on a source who's been wrong many times in the past might circumstantially support, what reasonable person could ever believe that? And just because the publisher makes statements or offers evidence that, I believed it to be true, that's not enough in the face of clear evidence that would show that no reasonable person would have ever believed that. But it's pretty extreme. It's a very difficult thing to prove. There's no question about it. And even when the Supreme Court wrote New York Times against Sullivan, and let me do my little plug here while I think of it. I have no interest in this book whatsoever. But if anybody leaves this proceeding tonight and has any interest at all in this subject matter, this book, Make No Law, it might actually be out of print now, but I know you can get it on Amazon, by Anthony Lewis. Anthony Lewis was a syndicated columnist for the New York Times, is about New York Times against Sullivan. It's about the history of the First Amendment that preceded New York Times against Sullivan. And what I really find interesting about it is it actually has an early draft of the opinion that the Supreme Court ultimately issued that they found in the archives. So it's got the actual opinion, but it also has an earlier draft of the opinion. So it's a great book, Make No Law by Anthony Lewis. If the plaintiff is going back to defamation again, if the plaintiff is a private figure, it's enough just to prove that the publication was negligent, that he had no reasonable grounds to believe that it was true. Now that's much easier to prove. Negligence is much easier to prove than knowing falsehood or reckless disregard for the truth. or what the Supreme Court has referred to as actual malice. You'll hear the term actual malice in libel law. Actual malice doesn't mean what you would think it means. Actual malice, you think means, oh, you hated that person. You had malice towards that person. Actual malice in the field of libel law means knowledge of falsity or publication while having serious doubts about the truth. It was probably an inartful term for the court to use, but it did. But if the plaintiff is a private figure, then it's enough to show, for that plaintiff to show that the publication was negligent, that you published something without doing a reasonable investigation, without checking your facts, without crossing your T's, without dotting your I's. That's good enough. And finally, you have to prove damage to the reputation in the sense that it deters right-thinking people from associating with the plaintiff. That's what it takes. Oh, see, I can't see very well. You get me in a spot.
Twitter is considered public.
Well, I'm sorry?
Twitter is to publish.
Is it?
Is it?
Yes. That's an easy question. Yeah, publishing is just communicating information to some third person. Now again, I mean, Twitter is publishing it on the internet, so it's available to third persons. Now, sending you an email wouldn't be publishing. Yeah, Dale.
How do they define who's a right-thinking person?
They don't. It's very result-oriented. I mean, criminals aren't right-thinking people. People in jail aren't right-thinking people. Some. Not everybody here. So I don't really know. I mean, it's one of those things, in the field of obscenity, Justice Douglas once said, well, I know it when I see it. And I think that's, there's some areas of the law where you're not going to ever have that bright line, that easy yay or nay.
Determine someone's public or a private person.
Well, I didn't bring a lot in on that, but basically, I mean, again, a public official is someone who's either elected to public office or who holds a public position where they can affect the public. Police officers are considered public officials. School teachers in public schools generally are not considered public officials, even though they can affect students. They don't affect, a sizable segment of the population. Public figures are a little more difficult. There's two kinds of public figures. There's what the Supreme Court has called pervasive or all-purpose public figures. That would be Britney Spears, Colin Kaepernick, people, sports figures, celebrities, people that, everybody knows of, and those are pervasive public figures. So they're in the public figure category. Then there's something known as a limited purpose public figure, and I can't really tell you what that is, but the Supreme Court has said that it's somebody who interjects themselves into a particular public controversy and becomes a public person for purposes of commentary on that controversy. The big vitamin C guy from the 70s, Linus Pauling, he sued once over criticism of his scientific, studies about vitamin C, and claimed that he was, libeled. And they said, well, no, for purposes of that controversy, you're a public person. You have to prove actual malice. You have to prove that the statement was made knowing it was false or while having serious doubts about its truth. So that, hopefully that answers your question, but in some cases, again, I know it when I see it. That's a celebrity. In other cases, you can win or lose a libel case as a plaintiff or defendant by proving that someone is a public figure. We had a case once with a singing group that was very prominent in its attendance at these programs that were put on by a group called Christian Identity. Christian Identity were people who believed in the supremacy of the white race, and it was kind of a religious type of group. They claimed they weren't Christian Identity, and they claimed that they were private figures. They sued over a news article that kind of lumped them in with Christian Identity, said that they were Christian Identity. We won that case we couldn't really prove that it was true or false one way or the other. And actually, it's their burden to prove that it's false. But we won that case by convincing the court that they had gone out there so much espousing things. And in fact, in their deposition, they touted how, what celebrities they were and how significant they were and what fantastic songwriters and singers they were. We were able to convince the court that that made them a public figure. So all that, what they had to show then was actual malice and not just that we were negligent in publishing a false statement about them. So you can win or lose a case based on that. As you kind of recognize, it's very difficult to prove actual malice. But there's a reason for that rule. And it comes out in New York Times against Sullivan again, and the court said, when public officials sue because of criticism of their official conduct, they must prove actual malice with convincing clarity. And the reason for that rule is, according to the Supreme Court, is to give breathing space to the First Amendment, to give, create an added burden for someone who's suing a publisher. It may not exist in the case of a private figure, because they've kind of interjected themselves into the public arena. They have the defense of being able to talk to the media and answer those charges, or they have the ability to do that. They should accept, there should be some assumption of risk there that certain false statements may be reported about them. And as long as the publisher doesn't know those false statements or those statements are false, then they should be protected. Now, in New York Times against Sullivan, I think this gives a classic case of why, and this is why I recommend the book, of why this is important. What was going on in New York Times against Sullivan was that there were many, many, many suits that were pending in the South against the Northern press over articles and, in this case, an advertisement. This ad, Heed Their Rising Voices, talking about the things that were going on with respect to civil rights in the South, the way that law enforcement was dealing with civil rights protesters, the way that blacks were being oppressed, and the public officials in those states, Alabama, Mississippi, filed numerous suits against the New York Times, the Washington Post. The Post-Dispatch was in one of them over those news articles, basically to shut them up. Now, $500,000 may not seem, well, for us here, it probably seems like a lot of money, but it may not seem like a lot of money for the New York Times. Today, it wouldn't be. But in 1964, when this case was decided, it was a lot. And according to what I've read, and it's talked about in this book, there were $300 million in lawsuits pending against the New York Times, the Washington Post, and other newspapers. It was an effort to shut the newspapers up, to stop the reporting by what was perceived as the liberal press. It was the use of defamation law, clearly for an improper purpose. And the Supreme Court saw that, and it adopted the standard that we have today. Now, a lot of people on the other side have said, well, this is bad because it encourages irresponsible journalism, because a journalist can just say, has anyone here ever seen the movie Absence of Malice? With Sally Fields, Paul Newman, and the Oatmeal Man, what's his name? Wilford Brimley, right, Wilford Brimley. It's a great movie. It's an old movie. I used to show it to my classes at WashU. There's a scene in it where Sally Fields is talking about things that she speculates about Paul Newman, who's suspected of, I think, knocking off some union guy or something like that, or having some involvement in it. And the lawyer for the newspaper, and I don't like the perception that they give of the lawyer for the newspaper, he says, well, you don't really know what happened, so therefore, absence of malice, we're okay, we can report it. Well, a lot of people think that. Well, New York Times did that. Well, I'll tell you this, I mean, you don't have to believe me if you don't want to, but I have disagreed with reporters before, but I have never seen a reporter that deliberately goes out and tries to cover up the truth. Now, they may have biases, like all of us, but I think it's very unfair to suggest that, well, this is just going to make them go out and not try to find the facts. because it doesn't work that way. They still try to find the facts. And the criticism of New York Times against Sullivan, some of it may be appropriate, but it's the law. It's the law, and until the Supreme Court changes it, and there's been some speculation that the Supreme Court might. I'll tell you this, from what I've read about the nominee, Gorsuch, he's not going to change it. He has no inclination to change it. He believes in it very firmly that we need to have this breathing space for publishers so that they're not afraid that they're not going to be able to prove it's true and therefore not be able to report it under the fear of a libel suit. The Sullivan court talked about things called chilling effects, that the fear of a libel suit has a chilling effect on free speech, and it does. It does. I mean, newspapers are afraid of getting sued. So that's why, one of the reasons why we have this added protection. Let's move on. Yeah.
When publication or clear media or some communication like that disseminates false information with the intent of alarming or persuading an opinion, a vote, or a purpose falsely, it's not libel because it's not directed against the individual, but what is that? Fraud? Is it actionable or not?
I would say no, it's not actionable. They're not defaming anybody. You're saying stirring up controversy with false facts?
Well,
that goes back to the fake news thing, really.
It is the notion of fake news, but we use the specific intent of manipulating a group of people as opposed to an individual. There is no set of laws that oversees, governs, or in any way monitors that.
Not really, not unless it's designed and imminently likely to lead to physical harm to a person. There was the case out of Idaho with the Matthew Shepard, where the preacher was convicted of some sort of criminal act. I couldn't, but basically inciting the kids to go out and kill this kid because he was gay, timed offense, and kill him. No. If it leads someone to purchase a car that they otherwise wouldn't buy, an economic transaction, then it could be actionable. All right. I said a protected opinion is not actionable, or opinion is not actionable. There are different kinds of opinion. Statements which are entirely subjective and not capable of being proven true or false in any reasonable sense. The worst lawyer, the terrible restaurant type statement. Those are always protected. You can't, Giovanni's on the Hill couldn't sue over I had a terrible bowl of spaghetti, or it was the worst spaghetti I've ever had. That would be pure opinion. Rhetorical hyperbole, statements which are ordinarily factual, but which, when considered in context in which they are used, become merely rhetorical ways of expressing a subjective viewpoint, are not actionable. Calling an abortion provider a murderer, for instance. That's an expression of my opinion that what he does is murders babies. That's protected opinion. Now, if the context, or if it wasn't clear to the audience that that's what I was talking about, and I just said he's a murderer, then, it might be actionable. But if it's clear from the context in which it's used that it's just rhetorical hyperbole expressing an opinion, it's not actionable. And then you have mixed opinion and fact type statements. Statements which contain both factual and opinion connotations. Calling someone an alcoholic. Normally that would be actionable. But if you express the facts on which it's based, he comes home every night, he pops open a beer, and he sits on his back porch smoking a cigar, I think he's an alcoholic. Well, then the audience, the listener, can decide for themselves, it just doesn't sound reasonable to me that just because the guy has a beer after he comes home from work, that he's an alcoholic. That's his opinion, but I don't agree with it. So that's what I'm talking about there. A case out of St. Louis County that is an interesting example of rhetorical hyperbole is Deal versus Fred Weber there. Fred Weber wanted to put in a trash transfer station somewhere in South County, and a group of citizens were very much opposed to it, and they put out this flyer: "Stop Fred Weber, 3 things you can do to fight the trash terrorists." Fred Weber, this was right after 9/11. And Fred Weber was very offended by it. But clearly, the publisher of that pamphlet wasn't saying that they're terrorists. They were using the word terrorist in a rhetorical way. And the Court of Appeals said, taking in context and considering the surrounding circumstances, a reader of the flyer would not believe that the company is a terrorist. Rather, the reader would recognize the language as an epithet used to voice opposition to the proposed trash transfer station, and neither imaginative expression nor rhetorical hyperbole can support a claim for defamation. Parody and ridicule. Another example. We wouldn't have SNL if parody and ridicule could be libelous. But, there are cases where parody may cross the line. If people believe it's conveying actual facts that are defamatory, then it's conceivable. This is an extreme example. I don't mean to offend anybody. Hustler against Falwell. This is a U.S. Supreme Court case. And what you find in the First Amendment context, by the way, is always these extreme cases on both sides are what make our law. But in Hustler against Falwell, Larry Flint was upset at Jerry Falwell because Jerry Falwell had criticized him in his magazine, his pornographic magazine, and published in his magazine this bogus parody Campari ad. And Campari always it's a double entendre type ad. They always talk about the first time. And the first time being, in this particular instance, Jerry Falwell in a little tryst with his mother in an outhouse with a pig. And Jerry Falwell, very much offended, and rightly so, I'd be offended too, sued. But again, the Supreme Court said, well, no one believes that. No one believes that. That's not conveying actual facts. It doesn't damage his reputation. So therefore, it's not actionable. Moving on.
I think maybe this may be a good place.
Okay, that's fine, yeah.
Because I think kind of moving on to a new topic here.
Yep. Hate speech. We've kind of talked about this. Hate speech versus free speech. And I think this is a great cartoon because and it's from Patriot Newswire. And because when you regulate hate speech, it affects free speech. And someone's hate speech may not be someone else's hate speech. And the Supreme Court, again, it's a content-based restriction. And the Supreme Court has laid down some very clear rules on the whole subject of hate speech. And those are on this next slide. Actually, no. But even though a message may be repugnant to most of us, the Supreme Court ruled in a case called RIV versus St. Paul that hate speech cannot be made criminally simply by virtue of the message being conveyed. That would be a content-based restriction and is not allowed under the First Amendment. In Wisconsin against Mitchell, the Supreme Court, that was the next year, 93, the Supreme Court ruled that it was permissible to enhance the punishment for a crime committed where the motive is hate. And you hear about that all the time, hate crimes. If the motive is hate, then you can enhance the punishment. You can make it a more severe crime. But you can't punish speech just because of its hateful message. In Virginia against Black, the Supreme Court, about 10 years later, the Supreme Court dealt with a case where a statute in Virginia made cross-burning illegal, with creating a presumption that the cross-burning was intending to convey a hateful message. Well, obviously it was. But unless that cross-burning itself is criminal, because you do it in here, or you do it on someone's private property, you can't enhance the punishment, you can't punish it. What rights do protesters have? I think that kind of answers it right there. Marching on the sidewalk, not impeding anybody, not preventing people from going in the store or the supermarket. That's protected by the First Amendment. Sitting in the middle of the street, I mean, you may say, well, nobody did anything about Ferguson and some of the other protests that have occurred here. Well, they tried to, and there's only so much that law enforcement can do. I mean, and I just read in the paper the other day that somebody was convicted of impeding the traffic flow. I think in that case they may have kicked a car too, but they did a little more than just sat in the street. But you know, you can't violate the law in that fashion. A protest cannot be restricted based on the message, and related to this, a protest cannot be restricted because of the likelihood of an adverse response. So just because, and that's a scene out of the Blues Brothers. Henry Gibson dressed as a Nazi. Remember, they were, if you've seen the movie, they were in a park, and all these maybe 10 10, 15 Nazis, and there's hundreds of citizens screaming and hurling things and everything else. You cannot prohibit a protest just because the protesters themselves and their message are going to have an adverse reaction. It may be a more difficult job for law enforcement to keep the peace, but just because the speech is disliked, it's called a heckler's video, or heckler's veto, rather. Just because the speech is going to be disliked and cause people to react violently, that's not grounds to restrict the protest itself. Protests may occur in areas that are traditional public forums. Traditional public forums are areas like public parks, streets, sidewalks, providing they do not unreasonably interfere with other users. And at other public places, the government has opened up to similar speech activities. Those are called designated public forums. The Quadrangle at University of Missouri is probably a designated public forum. It's been opened up by the university for public speech and public interaction. Private property owners obviously may restrict speech on their property. Do I need a permit to protest? In certain cases, permits may be required. A march or a parade that strays from the sidewalk, uses the street, a permit can be required. An event that requires blocking traffic or street closure, a large rally in a public park. The Supreme Court has said that if you intend to rally with more than 50 people, this was a case out of Chicago, that it's proper to require that the rally apply for and obtain a permit. You can't restrict the permit based upon what the rally is going to be about, because that would be a content-based restriction. Likewise, you can have a fee that would be reasonable to take into account administrative costs of the permit, but you can't have a fee that would be adjusted based upon the Henry Gibson situation, that you're going to have more people there reacting violently and you're going to need more law enforcement. Fees cannot exceed the actual administrative cost of the permit. And the courts have said that fee waivers should be allowed for groups that can't afford a fee. Reasonable guidelines must exist for the issuance of a permit and should govern the discretion of the issuer. A lot of what I've said right here, by the way, comes right out of the ACLU, which is very interested in protecting protesters' rights. But this is what they say. This is what they say. So here's a big issue. Can I videotape the police? Now, 20 years ago, that wasn't all that. I mean, the people who would be videotaping police were the broadcast media or photographers for a newspaper. But now, because of these things, anybody can videotape the police. I tried to find there was a posting on Facebook about a year ago of a person videotaping a police officer who was giving him a ticket, and you saw it, and the police officer was videotaping the person who was videotaping him. So there's two. And so obviously, and someone else obviously was videotaping that, but I couldn't find it. I looked everywhere, I couldn't find it. What's the law on videotaping police? It's been somewhat in a state of flux, but now I think it's pretty fair to say that providing you're not interfering with the police officer doing his duty, you're not screaming at him, don't give him that ticket or something like that, that the courts have pretty much said that that is a First Amendment protected activity, that you have a right to videotape the police. Now, courts have also said that the law is sufficiently ambiguous in that regard that if you're arrested for doing it and want to sue the police for violation of your civil rights, you're probably not going to win. Now, that'll probably change as the law becomes more definitive that people have a right to videotape the police. But most of the cases that I've seen have said, yes, there's a First Amendment right to videotape the police, but no, you can't sue them because the law is not determined enough or defined enough for the police officer to know that and for that to constitute a violation of your civil rights. Again, I think over time, it'll probably become more clear. Most police agencies now tell their law enforcement officers, people have a right to videotape you. Here's another one. Can Congress remove a painting it finds derogatory of police from the Capitol? This is a lawsuit that Lacey Clay and Michael Pulpus, I think is his name, have filed, over this particular portrait. And what I'm going to tell you about that is I really think the case, I mean, obviously the removal of that painting was content-based. Nobody removed it because it was, I mean, they said they removed it because, you know, didn't fit within the guidelines or anything else, but that's still all content-based. The question's going to revolve around whether the Cannon Tunnel between the, under the Capitol is a public forum or not. Because if it's a public forum, then a restriction on speech is probably improper. The painting was submitted in response to a contest where each congressperson is entitled to sponsor a selected piece of artwork. Winning paintings are displayed in the Cannon Tunnel of the U.S. Capitol. Paintings are judged by a panel. The panel must adhere to the policy of the House Office Building Commission. The painting was displayed for almost a year, well, 8 months, without issue. Fox News reports and some other news reports were critical of the display of the painting, and on January 14th it was removed. A lawsuit has been filed. I think there's a hearing set next week in that lawsuit. So I don't know what the result is going to be, but you know, I think there's a good chance that that the court may say that that was a violation of the First Amendment. I don't know if it was a violation of Lacey Clay's First Amendment rights, but possibly the artist's, because it is content-based. But it's all going to revolve around whether the Cannon Tunnel or not, or Cannon Tunnel is a public forum.
Excuse me.
Yeah.
There was a phrase that said you couldn't have something that was, I think it said the subject of contemporary political.
Yeah. I know what you're saying. It said, I'm afraid to go back because I won't get back here again. Must not depict subjects of contemporary political controversy, and clearly it did, and clearly that probably would have been grounds not posted in the first place, but it's been up there for 8 months. It's been up there for 8 months, and then it's removed. That's where the problem lies. That's where the problem lies. You let it, arguably you've made that a designated public forum by letting it up there, and now you're taking it down because people object to it. I'm not going to predict the outcome, but I think there's a good shot and by the way, they're not suing for money damages or anything like that. You're just suing to put the painting back. If it's on the internet, can I use it? People ask me that. Yeah.
Isn't it fairly easy for public safety to act on behalf of entities that don't want to protest to make it look like it's for reasons of order?
That would be, yeah, that would be a pretext, and yeah, I mean, you can use context to prevent content that you don't like, but you know, that is not proper under the First Amendment. And if it can be proven that you're using the context, you're using reasonable regulations, what appear to be reasonable regulations, really to restrict content, to restrict the message, then that would be a violation of the First Amendment. I mean, you know, that would be something the court would have to decide. If it's on the internet, can I use it? It's a question I get asked all the time. People see something on the internet and they think, well, you know, it's a photograph on Facebook, I can use it. The media doesn't. The media doesn't. But that photograph may be the high school yearbook photograph of the person. And that photograph is copyrighted. And the copyright doesn't belong to the person who owns that photograph. The copyright actually belongs to Jostens, the company that took the photograph. That's why you can't go into Kinko's or Walgreens and make copies of yearbook photos and stuff like that, they restrict that, because the tangible property you may own, the photograph you may own, but the intangible right to reproduce that photograph is not yours. It belongs to the photographer. And so taking something off the internet can create a copyright problem. Now, I understand there's going to be, in a couple of weeks, someone who's going to talk about intellectual property and copyright, so we don't need to get into that too much. I just want you to realize that don't assume just because it's on the internet that you can use it. Now, there is a defense called fair use. A defense exists for copyrighted materials that are used for fair use. And the courts take into account, what are you using it for? the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the whole, and the effect that it would have on the market. Because keep in mind, the purpose of copyright law is to encourage people to create things by giving them the monetary reward for creating it. So if you're not interfering with that monetary reward in the way that you're using it, then it's more likely that that's going to be deemed a fair use. Here's an example of a fair use. If you've seen Jersey Boys, the play, the Jersey Boy producers used a 7 or 8 or 9 minute clip from Ed Sullivan. Whoever owns the Ed Sullivan show, I don't know if it's CBS or whoever it is, it's something called SOFA or Dodger Productions. Wait a minute, no, it was SOFA, I think. Dodger Productions was the Jersey Boys people. Sued for copyright infringement, but the court said no. You're not affecting the marketability of people who are going to want to watch the Ed Sullivan show or buy tapes of the Ed Sullivan show. You're using a very small portion of it. You're using it for entertainment purposes, and therefore it's a fair use. Just the opposite, Abbott and Costello's routine, Who's on First, which I have on my phone. I think it's one of the greatest routines ever. There's a play, I've never seen it, I've seen Jersey Boys several times, but I've never seen this play, where a kid in a sock puppet does the whole routine to his girlfriend. He's a troubled kid, and the play's about his being troubled and everything else. And they use the whole routine, though, and the owners of, obviously not Abbott and Costello, but whoever owns the rights in that spiel now, sued for copyright infringement. They claimed, the playwright claimed it was a fair use, and the court said, no, it's not a fair use. Using the whole thing, you're not transforming it or modifying it in any way. It may be entertainment. It may not have a lot of potential for interfering with the market for those who want to see Abbott and Costello, but that's not a fair use. Now, that's just an example of how difficult it can be to determine whether something's a fair use or not. I'm going to move on. Maybe we'll go back to this. Leaks and anonymous sources. I said we'd talk about that. There's been a lot of talk about, leaks from the White House. Now, keep in mind that, or leaks about the White House. Keep in mind that a lot of what you see in the newspaper where they report on anonymous sources, confidential sources, those are trial balloons. I mean, they're not really unauthorized. They're just anonymous. They don't want their name associated with it, but those in power, the government officials, the White House, whoever, really wants that information out there. They just want to be able to have plausible deniability if it's not particularly accepted. But a lot of times, when you're talking about confidential sources, you are talking about the traditional whistleblower, the traditional leak. And I said earlier that there is a privilege that courts have recognized with some ambiguity, it's not entirely clear, for confidential sources and the media's right to protect confidential sources. Journalists obviously act under a code of ethics under which a promise of confidentiality to a source is considered sacred, and that failure to keep such promises would likely cause sources not to come forward. I mean, if once you're burned, you're not going to come forward and talk to the news media again. So they do believe that those promises should be kept and kept sacredly. Likewise, there are court decisions out there that say if a journalist promises confidentiality to a source and then without that source's consent identifies that source, that they may be sued for breach of contract on a breach of contract type theory. In Brandsburg against Hayes, the Supreme Court held that the government cannot subpoena reporters simply for the sake of exposing a source that would be confidential or to harass or endanger source relationships. But the court also said in that case that disclosure would be required where the subpoena was served on a reporter who had witnessed drug activities actually had been allowed to not participate, but to see the manufacture of hashish and marijuana. And it was a grand jury subpoena, and the Supreme Court said that in that particular context where the reporter witnesses a crime, and there's no other source for that information other than the reporter, that any privilege of the reporter must bend. Yeah.
Wouldn't disclosure of classified information also be a crime? A reporter who hears that is obviously
Quite likely. In fact, that came up with the case with the guy who lived out in O'Fallon about a year and a half ago, where the government was pursuing the reporter. I can't remember if it was a New York Times reporter or what. Maybe you remember, Dale. I think it was a New York Times reporter, to basically testify against the guy, and the government finally backed down and didn't pursue contempt proceedings against the reporter for doing it. The guy was still convicted based on other evidence. But basically, what the courts have said is that if the reporter has got information that pertains to a serious crime, and he's the only source for that information, then any privilege is going to bend. But usually there's a long fight that precedes that. You may remember Judith Miller. That went on for 2 years before that was resolved. And in there, we were just talking about lying, a government official lying, a perjury charge, not a serious crime beyond perjury. But clearly, if the reporter had information about a terrorist activity that was about to occur, something like that, the privilege would have to bend. The privilege would have to bend. Here's another issue. What information does the government have to share with you and with the media? That's obviously fairly significant now, because you've got government officials who aren't talking to the media, who have actually put locks on their doors so that the media can't get in, aren't answering questions in press conferences, and are using social media for the purpose of conveying their message without the benefit of anyone really challenging that message or anything like that. Can you do anything to stop it? No, not really. Just because someone's a government official, it may be bad policy. It would certainly seem to be poor policy for public officials to refuse to communicate with the public or media, but for the most part, no law requires them to do so. Government officials can choose who they want to talk to or who they want to give interviews to. However, they cannot open events, press conferences, and things like that, and exclude certain members of the media because they disapprove of what that particular media entity reports about them. That would be an improper content-based restriction, right? So they can't do that, but they don't have to talk to someone if they don't want to. But then there are laws, FOIA, Freedom of Information Act, and the state open records laws, which create certain rights on the part of the public to attend public meetings, such as this board, the county council. Now, there's exceptions to that where they can close meetings, but there are laws that deal with that and give citizens the right to attend the public meetings and to obtain documents from the government. Now, sometimes it can be like pulling teeth to get that information, but generally the courts will enforce those laws. Although the laws differ in language from state to state and the federal statute, disclosure of public records and openness of public meetings is generally the rule. In other words, they're presumed to be open, not the exception. All persons, not just the press, have equal rights of access. All records are presumed open, and exceptions are listed, in other words, identified specifically within the statute, and narrowly construed rather than the other way around. In other words, the presumption or in cases of doubt, in Missouri, the Supreme Court has said the tiebreaker. If you can't decide whether an exception applies or openness applies, the tiebreaker is a presumption in favor of openness. Yes?
Just because it's an open meeting in a public governmental body doesn't mean that you have a right to speak at that meeting.
Correct.
Because the rules of the governing body sets that in the definition. That's it.
Right. Absolutely. The burden is generally on the governmental body to justify withholding documents or the closure of a meeting, not on the person making a request. And only the actual cost of copies can be charged if you're asking for documents. And there is, under these statutes, generally a right of seeking court review where access is denied. Some of the common exceptions, law enforcement records, that makes sense. If the request is for a document, and if the document were released or the information were released, it would interfere with enforcement proceedings or deprive a person of a fair trial or constitute an unwarranted intrusion into personal privacy. I've got the Vince Foster suicide photos case there. That was a case that went up to the Supreme Court that dealt with whether or not I think it was Judicial Watch wanted the remember Vince Foster worked with Hillary Clinton at the Rose firm in Arkansas, and then was in the White House for a while, and then killed himself at Rock Creek Park, shot himself in the head. This group wanted the photos of the scene and the autopsy photos, and the government said no, that would constitute an unwarranted intrusion into the personal privacy of the survivors of Vince Foster, and the court agreed with that. The court agreed with that, and the photos were not released. There was no particular newsworthy purpose for releasing the photos, as far as I can tell. Things that would disclose the identity of a confidential source. Obviously, you need to protect your confidential law enforcement sources, or confidential information that would be obtained from that source. Things that would disclose unknown investigative techniques and procedures, things that would endanger the life or physical safety of law enforcement personnel, are all exempt as a general rule. National or state security matters are generally exempt. Private information disclosed to the government. Your tax returns, just because the government has them doesn't mean they're public. They're not. They're exempt. Not only are they exempt, there's a federal law that says, and we're going to talk about that in a minute, there's a federal law that says that it's unlawful to disclose that information. Personnel files of public employees, except for their salary and other emoluments. People who work for the government don't give up their right of privacy just by virtue of the fact that they work for the government. But what they're paid is public information, because you're paying it. Litigation strategy matters. If a public governmental body is talking to its attorney about how to defend a case, that is exempt from disclosure, because if it wasn't, then the other side could ask for that information, or the newspaper could ask for that information, report that information, and the other side would know it. So litigation strategy matters are generally closed. Public bids before the bids are open. I should say sealed public bids before the bids are open or closed. One bidder can't make a public records request for the other bidder's bid before the bids are submitted. That only makes sense. Plans are to acquire or sell real estate where disclosure could affect the price. If St. Louis County is looking for a place for a new county administration building, and is looking in Fenton, and is looking in Creve Coeur, and has its eyes really set on the Fenton property, it wouldn't be wise to let the owner of that Fenton property know that this is where they want to go, because all of a sudden the price is going to go up. So that kind of information is exempt. We had a case for the Post-Dispatch against the Convention and Visitors Center, where the Rams didn't want the public to know, or the CVC didn't want the public to know what the plans were to renovate the stadium to make it among the top 25% of football stadiums, which, as we all know, didn't pan out anyway. And the court there said, well, yeah, okay, it's real estate, but where there's no third-party competitive market component to the real estate negotiations of a public governmental body. In other words, everybody knows the stadium's going to be here. And you're going to renovate the stadium. What you're going to do to the stadium, the public has a right to know, and they have a right to know what it's going to cost. So the court there said basic principles of open government favor public knowledge. Let's talk a little bit about internet threats and cyber stalking. This is a very difficult issue. What I'm talking about here is a repeated course of conduct that is aimed at a person and designed to cause emotional distress, fear of physical harm. It can be something like threats of violence. Oftentimes they're sexual. Spreading lies as if they're the truth, like saying a person has a criminal record or the person is a sexual predator. Posting sensitive information or photographs online. technological attacks, denial of service attacks, where you're just hitting a particular site to shut it down, cause it to crash. In a case called Alonis versus United States, which was decided just 2 years ago, the Supreme Court dealt with a situation of a husband who was posting very crude and vicious posts on his Facebook page about what he was going to do to his wife, or ex-wife, or wife who was divorcing him. There was a statute that said that if the person about whom those threats were made felt threatened, then that person, the person who was posting those things, could be criminally prosecuted. And Mr. Alonis was prosecuted under that statute. The Supreme Court threw the conviction out, saying that you can't focus on the beliefs, even if they're reasonable, of the person who the message is about, but you have to look at the intent. Is there a criminal intent on the part of the person who's doing the posting? In other words, Mr. Alonis. Was Mr. Alonis intending to cause harm to his wife? And he said he wasn't. The problem was that the government tried the case based strictly upon what the wife felt and not about what his intent was. They didn't focus on his intent. So the case was reversed. I don't know if it's still going on. I doubt it is, because the statute was declared unconstitutional. But the whole issue of internet threats and cyber stalking is a very difficult one. You may remember locally, about 5-6 years ago, the Meier incident, where someone created Lori Drew created a bogus Facebook, or actually it was MySpace then. I don't even know if that's in existence anymore, but it's kind of the same as Facebook. A site created a boyfriend or a boy who befriended Megan Meier. They had a nice relationship on this social media site, and then pulled the plug out from under her by saying that the world would be better off if you were dead. And the girl went into a closet and hung herself. There was very substantial review of the facts of that case by the St. Charles County prosecutor, who decided not to prosecute, saying that there's nothing I can show that Lori Drew did that was illegal. A federal prosecutor, a U.S. attorney in California, of all places, used something called the Consumer Fraud and Abuse Act to prosecute Lori Drew, claiming that there was fraud by her creating a phony or false website and web name and a false profile for this young boy. She was actually convicted of a misdemeanor offense under that statute, but the trial judge threw it out, claiming that they hadn't adequately proven the case. There are considerable First Amendment issues involved here when someone starts posting things on the internet. That people post things that are negative all the time, and where has it crossed the line? From being protected speech to being some criminal speech or something like that. So that is a very difficult issue. Someone posted bad things about me. Can I make the website take it down? Someone posts that you're a pedophile. It's just somebody put it on Facebook, or somebody put it on some internet site. Can you make them take it down? The answer is no, probably not. There's a federal statute, the Communications Decency Act, Section 230, says that an internet service provider is not required to police their site to determine if there's improper content on it, and cannot be liable. Now again, you can question the policy behind that statute. Is designed to promote the internet and protect internet service providers who have, it's very difficult to police your site, to review everything that's posted on your site. That part of the law, I think most people have no problem with. The other part of the law, some people may have problems with, the idea that they can be told that this is up there and refuse to take it down. The case I have here, Jones versus Dirty World Entertainment, involves thedirty.com, which had posted on it, I don't know if you can read this, but basically Nikki or Nick, here we have Sarah, a captain cheerleader of the playoff-bound, or once playoff-bound Bengals. Most see Sarah as a gorgeous cheerleader and high school teacher. She is also a teacher, but what most of you don't know here, Nate cheated on her, Nate, football player, with over 50 girls in 4 years. In that time, he tested positive for chlamydia and gonorrhea, so I'm sure Sarah has both. What's worse, he brags about doing Sarah in the gym and football field. The website actually encouraged people to post things about people. TheDirty.com kind of tells you something about the website. She sent over 27 emails pleading for removal of these posts from the website to no avail. And the trial judge, the district court judge in Tennessee, said that because the website encouraged negative postings, the website could be held liable when it refused to remove the bad statements from the website. When it went up on appeal to the Sixth Circuit Court of Appeals, the Court of Appeals reversed it, saying no, Section 230 of the Communications Decency Act is absolute. There can be no liability on the part of a website for what it posts or what it refuses to take off the website. Can I make them take it down? The answer is no. It's almost 9 o'clock. I'm going to open it up for questions. There's a couple other things that I'm happy to talk to people about who want to stick around, but we've gone beyond our time, or we're getting close to going beyond our time. So I think that we probably ought to wrap things up. I saw what they gave you as a handout. I know it's very difficult to read. I have difficulty just reading my notes. If anybody wants the actual PowerPoint, give me your email and I'd be happy to have my assistant email it to you. So questions?
I thought on the last presentation, the PowerPoint was sent out to everyone.
Oh.
Yeah, if it's okay with you, we'll send it.
Oh, yeah, that's fine. That's fine. I didn't know. Yeah, I'm happy to have you do it instead of me. Pardon? Yeah, that'd be easier. I'm happy to continue, but I don't want to keep people beyond their time. Yeah.
What sounds into that? It's free speech, but it's very much like you got more speech.
Yeah, I was afraid you'd ask me about that, and that's not on my list of things. That is we all have opinions about it. It is basically the Supreme Court. What the Supreme Court said was that a person has a right to express their opinion. A person has a right to pay others to say things for them. So therefore, just because someone's got more money and more opportunity to say things, it's still First Amendment protected activity. I mean, it was a 5-4 decision, I think. So not everybody agreed with that, and future courts may reverse it. But I really don't have a lot that I can say about it, except that. I know a lot of people disagree with it very much, and I know its impact, just like the impact with a lot of First Amendment cases, can be negative as well as positive. Yeah.
Can things be okay with a First Amendment, but still not? I mean, you can still take action coming around a different way towards their behavior, or what they say, correct?
Well, if something is otherwise unlawful, I don't know.
I guess I'm trying to think of a way that someone. Let me think about this.
Okay.
I'm not communicating well.
Yeah.
Is there any time limitation on freedom of information action, so that the request is delayed just Malice?
Well, in Missouri, the statute says that a public governmental body is supposed to respond within 3 business days. They can get more time if, it's because of the bulk of documents or the difficulty in obtaining it, if they explain to you within those 3 days that they need more time and tell you how much more time they need. if you're talking about bringing a lawsuit over refusal to produce the documents, the statute says you have 1 year to do it from the date of the request. The federal law, that can go on forever. That can go on forever. Does that answer your question? Okay.
Somebody posts something and you want to take it off the website, you said probably not. Does that also apply to things we see about like new photos being posted? Is that the same thing, or should they get them taken down?
The website is not liable if they refuse to take it down. Now, if it's pornographic, but just a nude photo probably wouldn't be pornographic. But I mean, most websites, I mean, the dirty.com might be an exception, but most websites, if you go to the bottom, they have terms of use and privacy policy, and you send them a notice, and they'll take something down that violates their terms of use, and clearly, something like that would violate their terms of use. But if you're asking me in the abstract, if it was posted on the dirty.com and they said, no, we're not going to take it down, and it's not obscene or otherwise unlawful, no, Section 230 says that they don't have to. Now, you can bring what's known as a John Doe lawsuit, where you sue John Doe, the person who posted it, and seek discovery, serve a subpoena on the dirty.com to find out who that person is, or at least the URL, that, the address that posted that, and then sue that person to have them take it down. But that's a very difficult venture and expensive too. Yeah.
I have heard, and I guess more of my question is this true, that there are several states trying to pass laws to criminalize public protest? And if they are, how can they do that if it's protected speech?
Well, the answer is I don't think they can. I haven't heard that. Public protest per se, I mean, clearly you can...
Well, you can run people over if they're in the street because that's not a safe place to protest.
Well, I wouldn't say you could run them over. I mean, yeah, if you run somebody over, I mean, that's a criminal act. If they're in the street, that's a criminal act too, but two wrongs don't make a right. But I'm not aware of any state. If they are, I think there's a big problem with it, and I'm sure that it'll be challenged, and I would think...
I don't know if there's any states really trying to. I think there's particular legislators in particular jurisdictions who've introduced some bills to that.
Oh, okay.
They haven't really gone anywhere.
Yeah, I can't imagine they would, and if they do, the courts are going to throw them out. I don't think you have to worry about that. Yeah.
About injunction, if you knew that, say, a set of files of new photos of yourself was available, and you put out an injunction to prevent sites from publishing, and they did it anyway, what is what happens then?
Well, I mean, first off, if it doesn't fit within one of those narrow exceptions where a prior restraint is allowed, I'm not sure how you would get an injunction from a court in the first place. If you did get an injunction from the court, then it's probably going to be reversed on appeal because, it's an unlawful prior restraint. I mean, unless it involves national security matters or something like that, or it's an obscene photo or something like that. So I don't think that could really, legally, that wouldn't probably happen. I'm sorry, I think your hand is up. Oh, see, I've got a spotlight on me. Yeah.
My representative has refused to hold town hall meetings, but instead she held what is telephone on Facebook, but by invitation only. Is that a contextual restriction on my freedom of speech?
No, I don't think so per se. I mean, unless she's only letting people who've never said bad things about her or something like that. And I mean, arguably it could be, but I mean, a public official, I mean, just like you and I, they don't have to talk to people that, they have First Amendment rights too. They don't have to talk to people they don't want to talk to. So I don't know the answer to that exactly, but I would suspect that unless it's clearly...
Than the legislative body holding a meeting that they wouldn't let people into.
Right. Oh, I'm sorry.
When you go to a public meeting and they ask for your name and the address, can you use a John Doe?
Well, I don't know the answer to that. Can you use a John Doe if they ask for your name and address when you, I assume they have a sign-up sheet or something like that?
They say name and address for the record,
Yeah.
and you use John Doe. Is that permitted?
I have no awareness of anything that would say that it's not, and I can't see why, why they, under the public records law, they cannot require you to explain the reason you want a document or even identify yourself. So I would say the answer to that question is most likely that, they can't require you to post your name if you don't want to post your name.
Unless it's within their governmental body restrictions.
Even then, I'm not sure that'd be consistent with the public records and the public meetings law.
Okay. Second thing is not-for-profits. Do not-for-profits on the issue of transparency, First Amendment rights, trying to get information about the not-for-profit. Is that restricted?
Well, I don't know who said it out here, they're probably a private entity. Now, there's something called a quasi-public governmental body that has got such a close relationship with a public governmental body. What?
Missouri Bar?
Missouri Bar, yeah. We're probably, arguably.
They're on you say Missouri Bar, you can go to a site that is open to the public and pull up the Missouri Bar financial return, the 990 that is filed. And it's publicly disclosed because it's a public entity.
Yeah.
And if you want to know, you can write and ask for the information to the entity, and they have to give you disclosure, unless it's issues, some legal issues.
Well, not.
Give it to you as not, because I used to work for them. They don't have to give it to you. You may practice and give it to you.
Well, not-for-profits too. If they're a 501c3, they have to submit a 990 every year with the Internal Revenue Service, and that's a public document. But if it's a religious entity, like Larry Rice or Joyce Meier or something like that, they're not required to file a 990.
But if an agency is receiving federal funds or state funds, I believe it is open, but trying to get to the information is very restricted.
I think there has to be more of a symbiotic relationship than just getting some money from the federal government, but I don't really know the answer to that.
In a town hall meeting, can the public ask a question of the speaker at the public or the town hall meeting, or is that restricted by the guidelines established by the town hall meeting?
I think it depends upon the policies of the particular meeting. I don't think they have to allow the public to speak.
The definition of a town hall meeting, when you look at the definition, it's an interchange. But when you're speaking one way, that's my question.
Yeah, I don't think there's a statutory definition of a town hall meeting that requires someone, requires the public governmental body to give, I think it's bad policy. But
We're talking about an individual elected official holding a town hall meeting. Same laws don't apply to that would apply to a public governmental body that's holding a meeting.
well, you mean just like a news conference or something like that, or?
No, I mean a town hall meeting where it's like one legislator is holding.
Oh, well, that's not really a public meeting in the sense of the statute, right? Yeah.
All right, folks. Well, I want to thank our speaker before we leave.
Thank you. Sorry.